Hi, everyone. Good afternoon. We're going to go ahead and get started. Thanks for taking some time out of your busy day to join us. I'm Jenna Kirsten, your moderator for today's webinar on internal accountability. A few things before we dive into that discussion. All attendees will be muted throughout the session, but we do encourage you to ask questions using the Q&A feature located in the GoToWebinar toolbar. I'll monitor those throughout the hour and we'll have some time reserved at the end to answer those. This session is also being recorded and everyone will receive a link to the recording as well as a copy of the slides in your inbox. You can re-listen or share with your colleagues. You can expect that probably sometime tomorrow. Just a little bit of background about who we are. Kirkpatrick Price is a licensed CPA firm providing assurance services to clients worldwide. Our firm has over 13 years of experience in information assurance by performing assessments, audits, and tests that strengthen information security and compliance controls. We offer information security services such as audits, pen testing, plus readiness and guidance on frameworks such as SOC 1 and SOC 2, SOC for cybersecurity, PCI, HIPAA, HITRUST, FISMA, ISO 27001, and GDPR. We also encourage you to connect with us by subscribing to our blog, visiting our library of recorded webinars so you can catch up on any series, and following us on LinkedIn, Twitter, and Facebook. Now I'd like to welcome our speaker for today, Mark Heinley. You've probably heard him before. He's our resident privacy expert here at KP. He has over 10 years of experience in private practice, regulatory affairs, and internal regulatory compliance. Welcome, Mark.
Thank you, Jenna, and thank you to all of you for joining us today as we talk about accountability and monitoring internal compliance. Before we start, I have to give our typical legal disclaimer to let you know that this presentation is provided by Kirkpatrick Price purely for educational and informational purposes and does not constitute legal advice. So no attorney-client relationship is established by viewing or participating in this presentation, and if you do need legal advice, we recommend that you consult with your own attorney. Now that we've got that out of the way, we're going to talk about first why, before we get into our agenda, why internal accountability is important. Most of the time when we're talking about internal accountability and maintaining or developing compliance, the conversation is really about becoming or developing compliance. I've got 4 examples here on the screen before you, not to pick on those organizations, just to establish some credibility for that concept. That's the first step. Becoming compliant is the first step. You can't maintain something you don't have. But initial discussions are always about becoming compliant. And then usually what happens is resources follow that initial discussion. So resources are all about becoming compliant. So time, money, people, technology are all spent on that sort of initial push to get to some sort of satisfactory level of compliance. And that makes me think of the classic Ron Popeil, Set It and Forget It, the famous Showtime rotisserie cooker that was sold in infomercials, I think in the 90s. That was the classic tagline, and Ron is the inventor of the famous pocket fisherman, which sounds made up, but it is an actual fishing pole. But I think that sometimes compliance gets talked about in the way that the Showtime rotisserie cooker gets talked about. It's you start it and then you're done, and that's because it's starting compliance is always becoming compliant is always the first step, just in purely chronological terms. The resources are generated on getting there, and then there's this burnout that comes. So much time and energy and resources are spent on that initial push, getting to this level of compliance that's been established by either internally or externally. And then there's this need or a desire to move on to quote unquote revenue generating activities, or the things that a person or a group are generally tasked with doing, especially if compliance activities are assigned to people who are not compliance officers or not within a compliance department, and they have other work that may have struggled while they were focused on this goal of becoming compliant. So So one of the things we thought would be important is to help organizations who have already had those conversations and are now sort of the second stage of compliance. That's what this webinar is designed for. We're really going to talk about the second stage of maintenance and to some degree improvement as well. So this webinar assumes that you've already identified your compliance requirements. Now, just a note, our first agenda item at a high level will help you identify some areas that might establish compliance requirements for you if you don't already know what they are. But this assumes that your organization's privacy controls are already in place. And what we're going to do is give you some general principles that can apply to any privacy program. So this webinar isn't designed to just apply to GDPR or CCPA or any other US or international data privacy requirement. And we do put out webinars that educate on specific privacy requirements that provide really specific guidance on the requirements of those laws and those regulations. But we try to balance those webinars out with webinars that educate on general principles that can apply across the board. So if you need some more specific information on a particular privacy requirement, go back to our resources on our webpage that Jenna mentioned, and then also look to the future. We're going to keep putting out material on some specific privacy requirements in the future. But in this case, we're going to talk about some principles that can apply across the board. Now, we'll use some examples that are hopefully specific enough to help illustrate these principles. But really what we're going to do today is talk about a compliance approach of principles rather than sort of specific elements from any particular law. So now that we've kind of got those two notes out of the way, let's talk about our agenda. We're going to cover a decent amount of material today. We're going to talk about scope. That's what actually we have to maintain compliance of. We're going to talk about actual internal accountability activities. Sometimes I think when we talk about accountability and maintaining compliance, the concepts that are used in the discussions is too vague and not specific enough. So we're going to be brief but particular, give you some things you can actually take away and perform in order to help your organization be accountable. We're going to talk about scheduling accountability activities, documentation, reporting, corrective action, and those are those first 6 bullet points are really the body of a program that would allow you to maintain compliance. And the last bullet point there, maturity model of compliance, is more of an approach to give you a sense of perspective on no matter where your organization is in terms of sophistication in either obtaining or maintaining compliance, kind of a roadmap to what steps you could take to improve and to give yourself some permission to acknowledge where you are so that you don't get frustrated or your organization doesn't get frustrated with compliance efforts. All right, let's get into the first agenda item. Let's talk about scope. This is, as I said, this is the area you actually need to monitor for compliance. And since we're not talking about specific requirements, we're not going to go through a list of GDPR requirements or CCPA requirements. But we can give you, if you're trying to figure out what either you need to become compliant or even you've taken a bunch of steps and you're trying to figure out what you need to monitor, what you need to maintain, both of those questions go back to this same consideration of scope. And I've given you 4 different parameters that might help you identify scope. One is requirements that are set forth in law. The 2 that we are talking about as a company with our clients most frequently right now are probably GDPR and CCPA from a privacy perspective. And then requirements that are set forth in your contracts. So the contracts that you have in place with organizations that are clients, and then contracts that you have in place with organizations that are service providers or processors. The third item that helps establish scope is your privacy policies. Now, these are some of the items in your privacy policy may be requirements, or should be requirements, if certain laws apply, but some of these items may actually be items that you voluntarily commit yourself to. And those are going to create obligations on your organization. We'll give you specific reasons for that in a minute. And then fourth, similar concept, your internal policies can also create scope. It's things that you might not be required to do, although your internal policies should include legal and contractual requirements. But your internal policies may also obligate you to certain privacy activities that are sort of by choice, specific to your organization, and those would be within scope for maintaining compliance. So let me give you a couple of examples to help support or give some clarity to this concept of what's within scope when you're trying to maintain compliance. So first, let's give an example from a legal example. So both GDPR and CCPA require organizations to maintain a process for deleting personal data in certain circumstances. So if your organization is subject to one or both of those laws, then you need to have a process to make sure that your organization is handling those requests in a timely and appropriate manner. So that's simply one legal requirement that would establish your scope, one aspect of your scope for maintaining compliance. So, once you've created policies, trained employees, maybe set up a portal, a web portal or a web form or a link on a web page to allow individuals to request that their data is deleted, that's the first step. But then the maintenance step comes into reviewing that process to make sure it's operating as designed. A contractual portion of scope, this quote is from an actual DPA. That's language is pretty common because I removed some of the specifics to protect the individuals who are parties to the contract. But it says processors shall collect, process, and use personal data only within the scope of the controller's instructions. So there are other parts of the contract and then addendums to that contract that specify what those instructions are. But those instructions set forth the privacy requirements, or at least part of the privacy requirements for that processor. And there may be some specifics that relate to that relationship that are not spelled out in GDPR or another law, but extend the GDPR requirements and create compliance maintenance needs for this particular processor. And then third, this is for your privacy policies, and it really applies also to your internal policies. In the US, and I believe this is going to be a regulatory approach around the world in general, the federal government can use companies' external privacy policies to enforce privacy requirements, things that are sort of voluntarily applied with. In this case, the FTC is saying that it could enforce U.S. companies' promises on GDPR, even though the FTC is not a supervisory authority within the EU. They could basically say, if you've obligated yourself to this, then we may enforce it for those individuals who aren't European data subjects. And I've got a quote here from a spokeswoman from the FTC. This is Juliana Grunwald Henderson. She said, if a company chooses to implement some or all of GDPR across their entire operations, and as a result makes promises to U.S. consumers about those specific practices, they must live up to those commitments. The FTC could initiate an enforcement action if the company does not comply with the EU data protection promises for U.S. customers. So here we have a situation where an organization on its own commits to using GDPR practices and applying those either rights or disclosures to non-EU data subjects, and the FTC says we'll enforce that as if it's law. So that's part of your compliance maintenance requirement, is to know what you said in your internal and external policies in order to make sure you're reducing your regulatory exposure. So what you need to maintain is set forth in law, in contract, in internal policies, and in external policies. Now that we've kind of given you some guidelines for knowing what you have to potentially review, let's talk about what actual internal accountability activities are. And we're an audit firm, so we're biased towards these activities. These are the things that we look for when we perform audits like GDPR audits and other information security and privacy audits. But these are activities that we also expect our clients to engage in order to maintain compliance. And so there's really two here. nothing groundbreaking, but hopefully we're going to give you enough specificity to know the difference between the two and actually how to implement the two. So we're talking about monitoring and auditing. And there are differences. Those terms shouldn't mean the same thing. Monitoring is an ongoing review of reported process outcomes conducted by someone within the business unit or processing area. And then auditing is a formal and systematic testing of process outcomes performed by someone or an organization outside of the business unit or processing area. So let me give you a couple of examples to help you maybe clarify the difference between these two activities. So for example, monitoring would be a chief marketing officer identifying the number of data subjects who gave consent within a month's period of time for GDPR compliance purposes. And they would simply either obtain a report or manually generate that number and then document it. Auditing would be a data protection officer or a similar individual observing the consent process, mapping documented consent to a sample of email addresses received during the marketing process. So it's the same activity. You're talking about data subjects giving their consent for marketing activities. In one case, the monitoring is the chief marketing officer who's responsible for this consent process, performing the review, and just maybe limited to just identifying the number, just simply saying we had 100 data subjects give consent within the last month or 1,000 or 10,000. And then auditing would be the data protection officer who's not responsible for marketing activities directly, coming in and seeing how the process actually works, looking at a web form or a consent form, and then actually taking a sample of those data subjects and confirming that individuals that the organization is marketing to actually gave their consent within that month's period of time. In terms of responsibilities, for internal auditing, it's usually going to be someone like the data protection officer or an independent internal audit function, or maybe a compliance officer or a compliance department. And the reason that it's important from an auditing perspective to have someone outside of the business unit or business area, or maybe the entire organization, if we're talking about third-party audits, is to avoid having avoid having a conflict of interest. The chief marketing officer may be a stand-up woman or man, but there is an incentive for the chief marketing officer to say that every data subject that the organization is marketing to gave their consent, if that's a requirement, because that's part of their responsibility. Someone outside of the marketing team doesn't have that incentive. So the CMO could theoretically improperly impact monitoring, but particularly auditing. That's why it's important to have someone else come in and validate what the chief marketing officer is saying. So those are the two clear, specific activities that I want to give you today to take away and implement. And we're going to flesh that out a little bit more. But those are the two actual internal accountability activities that I think would generally support your compliance needs, would support your organization's efforts to maintain compliance. Okay, so now that we know what we should actually do, let's talk about some ways to actually monitor and audit. First, monitoring and auditing should be scheduled. That may seem obvious, but best practices for internal accountability means that not only are you confirming that your organization is managing privacy correctly, but that your organization is confirming that the process for internal accountability is happening as intended. So you kind of got two layers of confirmation. So a good compliance maintenance program is going to have its monitoring and auditing practices scheduled in terms of frequency. And generally, you can go back to scope to determine your frequency. Go back to the law if there's any sort of frequency defined in the law. That doesn't always happen. Go back to your contract. That's much more likely to be a place where you find required reviews and audits. Go to, it's not very likely, but you could commit to something in an external privacy policy, a frequency of review, but much more likely an internal policy is going to be the place where you have a commitment, a defined commitment in terms of frequency. So if you don't have defined frequency in the law, the contract, or internal policy, and trying to create that internal policy, then I can give you some principles to two different areas, two different ways to think through what kind of frequency you should have. Generally monitoring is going to occur much more frequently because it's performed by the operational unit. It covers a smaller period of time, and it doesn't involve the kind of independent testing that auditing includes, and that testing is just time intensive. There's no way to sort of shortcut testing. Auditing is generally less frequent than monitoring because it covers a bigger time period, say a year as opposed to just a month. It's performed by staff that's outside of the business department and maybe even a third party, and it does involve that time commitment of independent testing. So just as a general rule before we get into frequency based on risk and based on process flow, monitoring should be more frequent and auditing is generally going to be less frequent. So if you need to create a schedule for your monitoring and auditing activities and you don't have a requirement to do something every week in a law or every week in a contract, how do you know how frequently you should perform your internal compliance activities? Well, you should use risk. Risk is the threats and the vulnerabilities that could expose privacy or remove privacy commitments or violate privacy commitments. They are the likelihood of that exploitation occurring and the significance of that exploitation occurring. So one of the ways to figure out how frequently you should monitor and audit is just using risk factors. So I gave you kind of the principle of risk, but let's talk some specific risk factors. So if the activity is being performed internally versus externally, your risk is lower because you have control in the environment. But if a third-party service provider is performing a certain activity for you, then your risk is greater because it's out of your control, and your monitoring should be more frequent, potentially more frequent. If the data processing activity, if the privacy issue involves sensitive or confidential data, such as healthcare data or financial data or employment data, then obviously there's a greater risk in terms of at least the significance of exploitation, if not the likelihood. If the activity involves intensive consumer or data subject exposure or interaction, there's definitely going to be more risk if there's a sort of a phone call or written communication between an organization and a data subject, or an application process that involves a large amount of interchange between an organization and a data subject. The more interaction that you have with a data subject, the more risk there's likely to be with that sort of processing activity, and that should impact the frequency of compliance activities. And then, not to be redundant, but the frequency of a certain processing activity. So you might have a processing activity that is very consumer intensive in terms of the interaction, but it may happen once every 2 or 3 months. And so the risk may be lower there. Or you may have an activity that involves sensitive data and occurs on a daily or even hourly or by minute basis. And in that case, you have much more risk because of the type of data that's involved, but also the frequency that the processing activity is engaged in. So one way to help identify the frequency and schedule the frequency of your monitoring and auditing is to look at the risk of certain processing activities using those 5 different areas that I just gave you. Another way to schedule, come up with a schedule for your compliance activities is to use process flow. This should work well and work together with your risk-based approach. Look at the way that your personal data comes into your organization, then is disseminated within and outside of your organization, and you should have monitoring and auditing activities that cover each of the points of that process flow combined with the risk factor. So you see this is a very basic diagram, but in this case, you've got customer data input, going internally to the marketing team of a retail. For example, this is a very basic flow, for example, for a retail business that sells clothing, for example, or shoes. You've got customer data going to the fulfillment center to actually process the order and deliver the order. You've got customer data going to internal marketing for their use to market to that customer, because if the customer's already bought from them, then perhaps they're more likely to buy from them in the future. And then you've actually got a third party who's facilitating the payment for the clothes or the shoes. And so at each of these different points, there should be a monitoring and or auditing function with a defined frequency. And then if we apply those risk factors that we just talked about on top of this process flow, then we'll come up potentially with a good schedule. So for example, the customer data input that goes to the third-party payment processor means we've got two risk factors. We have a third party performing the activity, and we've got sensitive or confidential information. We've got payment information involved. So the risk for that particular processing activity is higher and should involve a more frequent a review. The monitoring might even be daily based on volume and the organization's resources. There might be a daily review or reconciliation for the payment processing. And then you've got a second level where you've got internal marketing, and the risk for the organization is lower here because it's the function is being performed by the organization itself. But then we do have the internal marketing team sharing some of the customer data with a third-party data analytics company to figure out what products are being bought the most by which type of customer to hopefully capitalize on that information and increase sales. So initially the risk is lower, but then the risk increases because you've got third-party data analytics. However, you don't have payment information. You've probably got some non-sensitive or non-confidential information. So the frequency may need to be less than the review of the third-party payment processing activities. And the same goes for fulfillment. So I hope this kind of helps you to layer both the risk and the process flow together to see where your control points, where your review points should be, and then to help you think through the concept of frequency for these different control points. So once you've got a schedule, then and here's an example before we move on to schedule. This is a generically created schedule using some examples that you could probably think of yourself and some from our experience. On the left-hand side, you have the area of review. The next column gives you the frequency. The next column gives you the type of review that should be conducted according to that scheduled frequency. And then I've left blank, but this would also include the last performed review date and the next review date. So for example, we use this as an example when we talked about the difference between monitoring and auditing, but consent for web forms and cookies. In this hypothetical, we've got that review period should be conducted with a frequency of weekly, and the type of review is observation of consent logs. And this could be activity that can be performed both by the organization, by the marketing team, and then by, for example, internal audit. And you could document, the last date that was performed. In a weekly case, it's going to fill up pretty quickly, and then the next date that it's due. A review that's a little bit less risk averse because the nature involved is your privacy policy. In this case, the schedule for this organization has it to be reviewed annually. And the process involves reviewing the required disclosures compared to existing disclosures and then making any changes that are needed. So this is just a sample of what a compliance plan might look like to maintain compliance, to help you really schedule things out, make it clear. One thing that might be even more clear on this schedule would be to put whether it's a monitoring or auditing activity and who should perform it. So that's just an example for those of you who are visual learners to see what a schedule might look like. I think we can move on to our next concept. That's documentation. We've sort of overlap between what we just showed you. Your monitoring should have good policies and procedures and reporting, and your auditing should have good policies and procedures as well as reporting. The policy and the procedures should give more specificity than could be provided in the space that last slide, that really basic schedule included. And this should give you the real detail and the heart of what monitoring and auditing activities should be performed. From a best practice perspective, this is the way that I talk with my clients about. When I go in and I perform an audit, this is the way that I sort of approach an audit, and this is the way I encourage my clients to look at themselves internally. That either someone new to an organization or someone from outside an organization can come in and review the documentation, the internal requirements, and the performance, so both the policies and procedures and the output, the reports, and understand what's going on just by reviewing that documentation. And now, I'm not talking about perfect understanding. I'm talking about having a relatively complete understanding without having to talk to anybody, without having to ask for clarification, knowing I know what kind of testing and review should be done. I know who should do it. I know how frequently it should be done. I know what it should include. And then I go look and I find a report that matches up with that requirement, and the right person did it with the right frequency and included the right information. And I understand what they looked at. And if I wanted to, I could validate their work. I could go in and see the numbers that they got and the output they got for a certain time period. And I could go back to that same time period and look at the information and ideally come up with the same result. So that's a way of thinking through the kind of documentation you need, the kind of content of that documentation is how could someone, because this is literally what would be needed for a third-party audit, and I think it's what would be best to provide to a data protection authority or any kind of enforcement authority or a client. Say, we can show you, we can walk you from the end back to the beginning to show you exactly what happened to demonstrate that we're meeting our privacy commitments. So, and this is what's needed within business units itself, but this is also what's needed for senior management, executive management to know. It's difficult for them to maintain accountability if they can't walk based on the documentation they're provided, because they aren't going to be performing. Senior management's not going to be performing the review. They're not going to be the ones doing the monitoring or the auditing. And so they need to have enough clarity in the documentation to be able to offer advice and make changes as needed, because that's an essential component of that sort of review, and then change is an essential component of accountability. So we're going to talk through this a little bit in the next section too. We're going to talk about reporting actually, but just in brief, documentation is a requirement both on the policy and the reporting side for both monitoring and auditing. So let's talk a little bit about reporting. Your reporting should be directly born out of your monitoring and auditing activities. So there should be a really clear one-to-one relationship between an activity or a group of activities that are monitoring or auditing and the kind of documentation that comes out of that. There shouldn't be a gap where you're performing a review and nobody's writing that down in a clear manner and then sharing that with the right people. So reporting takes documentation. It requires documentation, and it adds to it the level of communication to different parts of an organization. This is the way that you tell key stakeholders what is happening for the purpose of decision making. And we know that compliance doesn't take place in a vacuum. We can't take the Ron Popeil Showtime rotisserie approach to compliance, because we can't just set it and forget it, because we deal with people and processes and devices and applications that are all imperfect. So the plans that might be set from a compliance perspective might be the wrong plans, and they might need to be adjusted because they were flawed in their design. Or the compliance plans that your organization creates might be relatively perfect in their design, but they might be flawed in terms of their execution for one reason or another. And so accountability means checking and adjusting, and you can't check or adjust what you don't measure. I want to look at a really basic example that I created of a report from, this data was actually pulled. Some of this data is real and some of it is fictionalized to expand the concept, but I pulled this from a report by a supervisory authority and edit it to add a little bit of necessary detail. So the sort of smaller report, we got two layers of reporting here. You've got the complaint number and complaint type. That was actually pulled from a supervisory authority report for GDPR purposes. And they received within a certain time period a total of 32 complaints about marketing activities. And those complaints were broken down by email marketing. 18 of those were email marketing. 11 of those complaints were related to text message marketing, and then 3 of those were related to phone call marketing. And so I just imagined that if all of these complaints related to one organization, and I'm sure they don't, but let's say that this was one organization's activity for a certain period of time, they should both have the documentation at a high level that includes the complaints that were related to privacy activities, that's the same numbers that the supervisory authority had, but they should also have enough information to get more specific. So for example, if we expanded out the three complaints that were phone-based marketing activities, the kind of information that you would need to be able to walk back and investigate what happens and then make decisions include things like the date that the complaint was received, the nature of the complaint, the date the complaint was resolved, if it has been resolved, and the nature of the resolution. So in this case, we've got 3 different phone calls. One of those complaints related to 3 different phone calls. One of those complaints was resolved with just sort of informally with the data subject, with an apology, for example. But the other 2 complaints, let's say that they escalated. And one of those complaints related to a supervisory authority investigation, and one of those complaints related to litigation. And so this is the way that an organization would be able to document and know what's going on in order to take corrective actions, which is what we're going to talk about in the next step. One best practice tip for reporting is that reports should be standardized to the extent possible. And what I mean by that is the same monitoring activity with the same frequency, with the same data elements, and maybe even the same documentation or presentation approach. So for example, if this slide in front of you, this approach was used by an organization for a certain period of time, for, say, for example, for a year, this covered a year's worth of privacy complaints. For the next year, they should, as long as everything is sufficient in that template, they should use the same data elements and the same presentation so that they can compare trends across time. So for example, they can look at their complaints and see not only the objective details, sort of the volume and the frequency and the dates that it occurred and the types that occur, but they can also see outliers faster. They can sort of see one-offs that occur if they expect a certain behavior based on a 12-month period. In that 13th month, if they find something really different because the reporting looks exactly the same, but the number has increased dramatically, or the type of complaint is very different, they should be able to identify that much more quickly if the reporting is standardized. So if it's a PowerPoint deck that has the same slides that are just updated with the numbers as they change, or a form that has all the mandatory fields, typically what I see from organizations that manage their compliance the best is they have a standardized approach that allows the individuals who are performing the reporting and the individuals who are receiving the reporting the best chance at identifying areas of noncompliance. And then another best practice tip for reporting is, just like I did, use data protection authorities or government reporting as at least an informative guide for the kind of reporting that you might need. If it has enough detail, that might give you a sense. If you don't have a reporting template for a certain issue and you find a government report on it, that might give you a template. Or other sources include third-party audit reports that your organization gets for itself, as well as reports from clients or vendors. Those are all good sources. Everybody's, if you find something useful from a third party, whether it's the government or a client or a third-party audit firm or some other third-party source, those are also good sources for helping you to identify ways that are effective in reporting activities. All right, so let's say that you've scoped everything out, you've performed your monitoring and auditing. Based on that scope, you've got a defined and scheduled frequency that is appropriate based on risk and process. You've documented all those requirements and the outcomes. You've shared that with the right people within a business unit and senior management. And now what happens with that information? The final piece in terms of sort of chronology, although this is a cycle rather than a linear function, maintaining compliance is a cycle rather than a linear function. But in terms of the last part of the cycle or process, it's corrective action. So there should be a flow up and down. Reporting would go up about monitoring and auditing activity and what's actually happening. And then corrective action would flow back down throughout the organization from senior management based on that reporting. So some of the elements of corrective action, things that you should have, it should be timely. Really good corrective action that is the right idea, but that is delayed, really mitigates the value when an organization has experienced some kind of issue. It really mitigates the effectiveness of that corrective action if you wait days, weeks, months, or years to fix what's going on. And mostly that's in terms of communicating with individuals to make sure things happen differently in the future. Technology changes, software that needs to be updated or edited. The software needs to be edited because you've got compliance exposure, regulatory exposure. But really, and if it takes 6 months to do it, there may not be any ways to facilitate a faster release date or something like that. But especially in terms of individuals and communication and training, it really needs to be timely to be effective. It should be proportional. So if there's an area with a ton of risk, with a high likelihood of occurrence and an extremely high impact if the threat or vulnerability was exploited, something that could be really embarrassing or something that could be really costly or something that could generate a lot of negative sanctions from a supervisory authority, whether it's just financial or in terms of sort of ability to operate, your corrective action should be proportional to that. If it's got a lot of risk and if it's a really bad situation, then the corrective action should be sufficient to address that. On the other hand, if it's a small item that occurs infrequently that is unlikely to generate fines or embarrassment, then the corrective action can be proportionate to that level as well. Just to continue the theme, your corrective action should be documented. So in some cases, I see organizations that when they do compliance reporting, they have opportunity for management to identify whether corrective action is needed within the same findings. So if there's that complaint report that we looked at earlier, if there was corrective action that needed to be taken on one or more of those 3 phone calls, there might be a place to identify what corrective action should be taken and who should take it and when it should be completed by. And then finally, corrective action, just like every other compliance activity, needs to be confirmed. So if something was supposed to be done, and we're going to look at some examples of training you guys see on the slide, but if policy changes should be made within a certain period of time, there needs to be confirmation that the policy changes occurred within that period of time. So why don't we go ahead and talk about some examples of typical corrective action items that we recommend and that we see: changes in policies, internal or external, training of employees, employee discipline if the issue is severe enough, changing a third-party service provider or vendor, or making sure that the vendor makes changes to itself if the relationship isn't terminated, if it's not that serious. And then technology implementation. Those are some of the more common ways that an organization looks at privacy commitments, finds something wrong, and then makes changes to address those privacy commitments. All right, those are the 6 different components of a program to maintain compliance and give your organization an opportunity, a good opportunity to have internal accountability. And so now we're going to kind of move on to how sort of the real world and the way things work. And sometimes when we talk about a compliance model, we talk about the crawl, walk, run approach. It would be great to have a fully implemented, funded, and staffed internal compliance program and oversight process that was operating at 100% right out of the gate with all the resources and time it needed to perform the kind of oversight that your organization needs. But if we don't have that, or we can't have that, at least not yet, then we can move towards the steps that we can take. So let's look at some specific ways that crawl, walk, run might look in a privacy compliance maturity model. So from a crawl perspective, this is an organization that's either new to compliance approach or new to privacy compliance commitments. And it has ad hoc processes, means things are kind of done as people see fit without any consistency. There's very minimal documentation. There's inconsistent implementation. There isn't measuring what's going on, and that there's usually suboptimal performance. Unless you're a large organization that starts off with lots of money or with people that have the required expertise and the time to do it, a lot of the times you're going to have to start off at the crawl approach, especially if you're a startup organization. But you can acknowledge that and then look towards the next step, which is sort of what I call the walk step, which would be defined and documented processes that are consistently implemented, but there might be minimal or average measurement, and then there would be average optimization, average performance. And if your organization is there, that's good that you've taken the time to define and document things, and you've got consistent implementation, and you have at least some measurement, some compliance assurance activities to determine what's actually occurring and how close is it to what's supposed to occur. But then you can also look forward to the run stage, where your processes are not only documented, but they're reviewed and improved. There is total program measurement from top to bottom and left to right. There is a top-down culture of compliance that is fully and consistently implemented, and then it is fully optimized. The performance matches the efforts and the maturity. So that's kind of the approach to say, when I've worked within organizations and compliance efforts, one of the things that I in my immaturity, I always tried to go from crawl to run right away. Crawl was never good enough, and we needed to be at run, and we needed to be there immediately. And just from a practical perspective, that doesn't work. In fact, that usually discouraged not only sort of peers, but also executive management from putting much time and effort into it, because they said, well, we can't get to that level. We're not going to spend that kind of money. We're not going to bring in those kinds of people. We're not going to buy that kind of technology yet. And I think what is a much more effective approach is to identify where you are in this maturity model, and then take the steps to move to the next stage, either one or all of those steps, and then exist in that phase to the best of your ability, and then look at the steps of the next phase until you're at the run stage. So that's just kind of a pep talk to say, if you're not at the place that you want to be in as an organization in terms of your privacy compliance assurance activities, here's a path forward, and take it one step at a time. All right, now let's kind of, as we wrap things up, talk about why internal accountability really matters. From my perspective, and this is not a statement that a supervisory authority or a frustrated consumer or data subject who's suing you it's not what they're going to say, but in general, maintenance of compliance and ideally improvement is as important as becoming compliant. It's not good enough to just set it and forget it. There's real opportunities for regulatory sanctions if you start something and don't check to see whether it's actually working, as there is and not starting to begin with. Second, accountability is a requirement. I've got some specific examples, some different privacy laws that back that up. The GDPR requires demonstrable compliance in both Article 5, which is entitled accountability, and then also for processors in Article 28, at least towards controllers, but in general, processors have to be able to demonstrate their compliance with GDPR. PIPEDA, which is the Canadian data privacy law, requires accountability. It's principle number one. If that tells you anything about the value that's placed on accountability, and one suggested way to comply with that accountability principle is to develop and implement a system to monitor your organization's compliance with the law on an ongoing basis. That's a quote from a website, a Canadian government website on the law. Develop and implement a system to monitor your organization's compliance. That's exactly what we've been talking about. And that's one of the ways to comply with the accountability requirement. And then CCPA, which is coming, the California Consumer Privacy Law. Auditing compliance with CCPA is a specifically identified business purpose within the law. So, that tells you what's not only permitted within the law, but I think what is expected by lawmakers. And when the Attorney General rolls out rules in the near future, hopefully in the near future, I expect to see some specifics on accountability practices, or at least principles about accountability practices. So just from a legal and regulatory perspective, accountability is not just good, it's required, but it's also good. Internal accountability makes it easier to respond to client and third-party and regulatory investigations. GDPR requires that controllers and processors have within their contracts that have audit rights. Now, for some organizations, that may not be a change in their contracting language, but for other organizations, that may be the first time GDPR compliance may be the first time there's both a legal and contractual impetus for audits by a client or auditing their own sub-processors. So if you perform internal accountability actions, you can find issues first and fix them before a third party, it's a client or a data subject or a supervisory authority, finds them. You can identify areas of non-compliance. You can identify areas of a lack of evidence of compliance. You can identify out-of-date policies or uninformed personnel. And if you create a good compliance management system, it's going to make the process to respond to third parties much easier. If you've got a policy library and a reports library, and you have the kind of review that your third parties are going to perform on you, then not only are you getting the value of that information for your own purposes, knowing whether complaint trends are up or whether you've got data access requests, you need to know that on your own. But when people come in to ask you about it, you ideally got all the policy and report documentation that they're going to look for, so you don't have to create new reports for third parties. That's to me the ideal maturity level, is when an organization can simply turn over what they've already done to a third party, whether it's an auditor or a supervisory authority or a client, and say, what you're asking for, I've already done, and I can give it to you right here. So, and then it allows for optimized resources. When if you've got an effective internal accountability program, you can spend money where you need it, where your risk is, rather than just trying to guess and overspending. You can reduce or eliminate duplication. I've seen situations where an organization had a business unit performing auditing and the compliance manager performing monitoring activities, where the roles should have been reversed and the frequency should have been reduced, and the duplication would have been eliminated. And then you've got the right people doing the right jobs. The same examples. You want to make sure people are performing the activities that they're capable and in the best position to perform. So hopefully we've given you a sense of what are some principles of a good internal accountability compliance management program, and a perspective on how to move from sort of a lower level of maturity to a higher level of maturity, and the reasons that having internal accountability is a good thing. Having shared all that with you, Patrick Price can help you with your internal compliance activities. We are an information security firm with data privacy services. We have people with the ability to simultaneously address both security and privacy needs, and we have the ability to provide those services for both global and custom privacy requirements. So if you need a third party to help you with specific auditing or monitoring activities, we can do that. If you need help learning how to do that, specific consulting, we can do that as well. Thank you for your time. I think now we're going to open it up for a few minutes for some questions. Is that right, Jenna?
Yes, we've got just a couple of minutes. If you have any, send them in now. I'll answer probably the most popular question: will you get the slides? Yes, we will send out these slides hopefully today, if not tomorrow. because I know there's lots of examples in these, and Mark did such a great job of providing those, so we want to get those out to you guys as soon as possible. And our next couple webinars, if you're interested, we're going to have some more privacy ones featuring Mark, and we'll also have a cybersecurity case study series where we'll be focusing on different industries and how cyber threats impacts them. So our first one is on the education sector. If you're interested, that'll be next month. And keep your eyes out for Mark's next couple of topics. But for right now, it's looking like Mark covered this topic pretty well. Let's see here. I'm not seeing any right now, so we'll wrap it up for today. But if you do think of any questions, feel free to reply to one of my emails, or Mark's email is on the screen right now, and we'll get you connected with him, and he'd be happy to answer any questions you have about internal accountability functions or privacy topics. So feel free to reach out. We're happy to help, and thank you for spending some time with us today. Have a great rest of your day.